Hi, this is attorney Richard Wright. I'd like to welcome you to Rockers TV. Today my discussion is on statute of fraud. Statute of fraud refers to certain contracts which must be in writing. Examples of contracts which must be in writing are, for instance, contract which require performance for over 1 year. If you enter into a contract which requires to be performed more than 1 year, then generally it must be in writing. Another example of statute of fraud is any sales of goods which exceed $500. Then it must also be in writing. A third example of the statute of fraud is any contract where property is exchanged for marriage or money is exchanged for marriage, then it must also be in writing. A fourth example of the statute of fraud is any bequest or device for property, that is, any bequest upon someone's death, then it must be in writing and it must follow the statute of wills formality. A fifth example of a statute of fraud is any contract which requires a finder's fee arrangement, such as a broker agreement, then it must also be in writing. A sixth example is to answer for one's debts discharged in bankruptcy. So those are some of the leading requirements of contracts which must be in writing in order for it to be enforceable. Quick recap as to contract which must be in writing are contract which cannot be performed within 1 year, contract for the sales of goods, contract which requires a finder's fee arrangement, contract involving the exchange of property, real property, contract which require the performance after a person's died, contract which require payment for marriage. Those are some of the contracts which must be in writing in order for it to be enforceable. If they're not in writing, they're in violation of the statute of fraud, and generally a court may not even hear those cases. So once again, thank you for watching Rockers TV, and I look forward to meeting with you next week on Legally Speaking.